Okay, so I think I will begin our session today, our first session of the Integrity at Work Conference 2021. My name is Stephanie Casey and I'm the Integrity at Work Programme Manager. And I'm very happy to welcome you all here today to our fifth Integrity at Work Conference. So just to give you a little bit of background to those of you who are new to the Integrity at Work initiative, the Integrity at Work programme was established by Transparency International Ireland 5 years ago now. And our objective with this programme is to support employers to foster workplaces where people are supported to raise concerns of wrongdoing and to act with integrity. Now, we know that supporting staff to speak up about any form of wrongdoing that they encounter in the workplace, any kind of fraud or unethical conduct, is one of the most effective ways of uncovering wrongdoing at work. However, we also know that one of the biggest barriers to staff in coming forward is a fear that nothing will be done in response to their concern. So with the Integrity at Work programme, all of the organisations who participate in the programme sign a public pledge, the Integrity at Work pledge. And that pledge commits our members to support people to come forward and raise concerns, to take action in response to those concerns, to protect the person from any form of retaliation or detriment for speaking up, and to signpost them to information and guidance in the process of raising that concern. And one of the places where employers can actually signpost their workers is the Transparency International Ireland Speak Up Helpline, which is Ireland's national helpline to support whistleblowers. And John will tell you a little bit more about that in just a few moments. We have 32 organisations taking part in the programme currently. As you can see here from this snapshot of the logos of the member organisations, we have a number of justice sector agencies who have been sponsored by the Department of Justice to take part. We have 3 institutes of technology who've been sponsored by the Department of Further and Higher Education to take part. And as you can see here, we have a number of regulators, prescribed persons, a number of charities, including Rehab, Throker and Action Aid. And you can see here at the bottom of the screen, our 2 most recent members to join are PUBL and A+. And I'm delighted to say that the Public Appointment Service have also confirmed that they will be joining the programme this year. I would just like to take a moment to thank the Department of Justice, the Department of Public Expenditure and Reform, and the Department of Further and Higher Education for their support for the initiative over the last number of years. So just turning to our conference this year. Now, as you will have seen, we have a very ambitious programme of events. We have 36 speakers taking part in 10 sessions over 2 weeks, so running from Tuesday to Thursday this week and next week. You will have already received an email from us with links which will enable you to register for all the different Zoom sessions. So we would encourage you to register for the sessions that interest you. And don't worry if you miss any sessions, because we're recording all of these sessions, and you can play back those recordings in the information pack link that we sent you in the email, which links you into a folder in OneDrive. So you can play back sessions at any stage. And we'll also include in there materials relevant to the different presentations that you will be hearing over the next 2 weeks. As always with all of our conferences, and certainly with this one, which we have designed to be a very practical series of sessions that will give you information and guidance as you prepare for the transposition of the EU Whistleblowing Directive, we really do encourage you to engage with us and ask us any questions that you may have at any stage using the Q&A button, which you can see on your screen. And if you'd like to make a general comment, please just use the chat button at any stage. If you have any technical difficulties, just send us a message using the chat and we'll do our very best to help you to get back online. So all of the information on the conference and on the Integrity at Work programme is available on our website, integrityaatwork.ie. And if you're on social media, we would very much encourage you to follow us on our Twitter account at @integrity_IE. If you are tweeting about the conference or posting anything on social media, we would really encourage you to use this hashtag as well, #IAW conference. So that's all from me for the moment. And now I'm delighted to hand you over to John Devitt, our Chief Executive of Transparency International Ireland.
Many thanks, Stephanie. And before I introduce Minister Michael McGrath, I should briefly thank you all for taking part in this, our 5th Integrity at Work conference. It's become such an important event in our calendar, not only because we get to speak with some of the most experienced practitioners and academics in workplace ethics and whistleblowing, but because each year we're learning a great deal from our participants who are shaping the conference with their feedback and their engagement in the program. And we'll continue to seek your input to make sure that the program helps build or helps you build working environments in which people feel safe in speaking up and acting with integrity. As Stephanie said, the program commits employers to prevent or address the penalization of workers that raise concerns of wrongdoing, act on those concerns, and signpost them to our helpline. And this helpline, the Speak Up helpline, has supported nearly 2,000 clients since it was launched in 2011 and provides information, guidance, and referral services to anyone seeking help in raising concerns about wrongdoing. The helpline triages cases, which are then forwarded to the appropriate authority, or where the client needs legal advice in making a protected disclosure, to our partner charity, the Transparency Legal Advice Centre. The centre was launched by TI Ireland alongside Integrity at Work in 2016 and is the country's only specialist independent law centre providing free legal advice to whistleblowers. Its solicitors are regulated by the Law Society of Ireland and the centre itself by the charities regulator. Since it became operational in 2016, it's taken on 100 clients so far and provided them with legal advice with an estimated value of €10,000 per client, or the equivalent of €1 million of free legal advice in total. Direct engagement with members of the public, workers, and employers informs all the work that we do, including our policy submissions, research, and guidance. And it means our work is grounded in experience rather than just in theory. In addition to the most recent National Integrity Index study, which examined the preparedness of semi-state bodies and universities to address corruption risks, we published analysis of safeguards against the use of Ireland as a safe haven for the proceeds of international corruption, and also looked at measures adopted by Irish companies to address corruption-related risks too. Next year, we'll publish our analysis of disclosure practices by non-commercial bodies, the latest Corruption Perceptions Index, and as part of our Speak Up helpline services, we'll roll out our case process review, new counselling, guidance, and psychological support services for whistleblowers, and a whistleblowing support fund. We're happy to keep you informed of developments, but please feel free to explore our website or the eponymous Integrity at Work website too. We're very pleased to have had the opportunity to work closely with the Department of Public Expenditure and Reform since 2011, who engaged with us and many other stakeholders when drafting the original Protected Disclosures Act, and have supported the work of the Speak Up helpline and the Transparency Legal Advice Centre since then. I'm also very pleased to introduce you to Minister Michael McGrath, Minister for Public Expenditure and Reform, who will talk to us about his department's plans for the coming year. Minister, thank you again.
Thank you very much, John, and thank you, Stephanie, as well. And good afternoon, everyone. I'm genuinely delighted to have been invited by Transparency International Ireland to give the opening address at this year's Integrity at Work conference. I think we can all agree Integrity at Work is an innovative initiative that supports employers in developing an open and an ethical culture in the workplace. And the annual conference is, of course, the centerpiece of the work that it does in this area and always attracts an impressive range of speakers. And this year is certainly no exception. I've looked at the schedule that you have out to Thursday of next week, and I think it's going to be a really super conference. So well done to all of you for organizing it. The theme of this year's conference is, what will new whistleblowing standards mean for your organization? And as you all know, the EU Whistleblowing Directive is due to come into force shortly, and this will bring about significant changes in terms of the legal obligations that will apply to the public and the private sectors in encouraging, supporting and protecting workers who speak up about wrongdoing in the workplace. The 10 webinars that make up the agenda for this conference are all geared towards helping organizations prepare for the significant changes that are coming up. I will talk in more detail in a little while about the approach we are taking to transposing and implementing the directive here in Ireland. But before I do that, I want to just take a minute to reflect on the wider context in which these changes to the rules protecting whistleblowers are taking place. We have undertaken in the Programme for Government to protect and enhance democracy through a series of political and public service reforms. In my role as Minister for Public Expenditure and Reform, I am committed to implementing a suite of reforms to our legislation concerning not only whistleblower protection, but also freedom of information, lobbying and ethics in public life. It's important to remember that reforms in all these areas are building on what is already very strong foundations. It is sometimes forgotten that Ireland performs very well in relation to transparency and accountability. We have a strong and independent judicial system, which is critical in enforcing the legislation in all of these areas. And this cannot be taken for granted. And of course, it does not mean that we can stand still in this space. There's plenty of work to be done, not only in improving legislation in these areas, but also in improving how we implement that legislation through engagement and enforcement. So in the area of freedom of information, work has begun on a review of the legislation, which has been in place in its current form since 2014. In recent weeks, for example, I've published a roadmap for this review, setting out the various steps and timeframes for the process. In brief, this includes a public consultation on the scope of the review and also a full consultation, which my department will seek detailed submissions on all of the key issues. In addition, my department is developing a customer satisfaction survey to gauge perceptions of the FOI process, as well as a methodology for estimating the administrative burden and the cost of the FOI system. As the review progresses, these key information gathering activities will be supplemented by a desk-based review of international best practices, interviews, focus groups, regional events, and other activities as required. This review is an ambitious programme of work and will conclude with a report and recommendations, which is scheduled for the middle of next year. And I want to encourage all stakeholders from all walks of life to please get involved and to have your say in this important review. It's a really good opportunity. Earlier this month, my department launched the initial public consultation on the scope of the review, which received an impressive 200 responses in the first 24 hours. And I think this shows the level of attention that this area is justifiably receiving. The consultation will be open until the 17th of December, and I would encourage all interested parties to participate in this process. A review of the 2015 Regulation of Lobbying Act was announced by the Taoiseach in September of last year, and my department's comprehensive review of the Act concluded in the summer of this year, and the government approved the preparation of the heads of a general scheme to amend the Act in July of this year. And I'm pleased to be able to tell you that the heads of the legislation are close to finalisation and will be brought to government for consideration in the very near future. The proposals to amend the Act will build on the existing strong legislative foundation and further strengthen Ireland's lobbying laws. Also approved in September were proposals I brought to government for a review of our public sector ethics legislation. This will address one of the last pieces of unfinished business arising from the controversies and critical examination of standards in public life that arose over the past 20 years in Ireland, as well as the significant work that has been done to date in implementing in developing the 2015 Public Sector Standards Bill. The review will take into account important recent developments, such as the Hamilton Report's recommendations on preventing economic crime and corruption, which was published last year, and of course the recommendations of GRECO, Council of Europe's group of states against corruption, on reform of our statutory framework for ethics. It will also take account of the Standards and Public Office Commission's experience of administering the current framework over the last 20 years. The outcome of the review will inform proposals for legislative reform that I intend to bring forward next year. And my ultimate goal here is to create an easy to understand and a user-friendly ethical framework that is fit for purpose and can contribute positively to the quality and effectiveness of our public administration. As part of this review, I will be launching a public consultation exercise very shortly. Last but by no means least, we are also committed to overhauling our national whistleblower protection legislation, the Protected Disclosures Act. And while this process is driven primarily by the requirement to transpose the EU Whistleblowing Directive, it is my firm intention to ensure that we also take this opportunity to reflect on the lessons learned regarding the operation of the Act since it came into force in 2014. The Protected Disclosures Act in Ireland was an innovative piece of legislation for its time, drawing on what was considered best practice by such institutions as the Council of Europe, the G20, and the OECD. And I would commend one of my predecessors, Brendan Howlin, on bringing forward and implementing that legislation. It continues to be highly ranked as one of the strongest whistleblower protection laws in the world. The amending legislation will go further in ensuring stronger protections for whistleblowers and placing a greater emphasis on ensuring that reports of wrongdoing are followed up and are actually addressed appropriately. So in this regard, the legislation will bring about a number of important changes, including the following. It will significantly expand the scope of the Act to provide protection for volunteers, for board members, shareholders, and job applicants who report concerns about relevant wrongdoings. It will place an obligation on all private sector employers with 50 or more employees to establish formal channels and procedures for their workers to report concerns about wrongdoing. This is an existing requirement, of course, in both the public service and the financial services sector, and the experience has been encouraging, with more people coming forward with concerns to employers and regulators also. Prescribed persons will be required under the new legislation to be more proactive in promoting their role as external recipients of protected disclosures, making their reporting channels clearer and more accessible to workers who wish to report concerns about wrongdoing in the sectors they regulate. Employers and prescribed persons will be required to acknowledge, to follow up, and to give feedback in respect of all protected disclosures they receive within a clearly defined time frame. And I believe this will have a very positive effect. All too often, the experience of whistleblowers has been that their reports just seem to disappear into a black hole, with no indication as to whether any action has been or is going to be taken. These new obligations will give greater certainty, not only to reporting persons, but also to employers and prescribed persons also. We're also enhancing the protections that will apply in the event that a reporting person suffers retaliation for having made a protected disclosure. In civil proceedings concerning allegations of penalisation, for example, we are reversing the burden of proof. So it will fall to the employer, not the worker, to prove that the alleged act of penalisation did not occur because the worker made a protected disclosure. The provision of interim relief will be expanded to cover not only dismissal, but other acts of penalisation as well. And I think this is an important development. as it will allow workers who suffer serious detriment to obtain urgent relief where this is necessary. Finally, criminal penalties will apply to persons who penalise or hinder reporting by whistleblowers or take vexatious proceedings against a reporting person, as well as for breaches of the duty to keep the identity of the reporting person confidential. In addition, in order to further enhance and improve the implementation of our protected disclosures legislation, I am proposing the establishment of a Protected Disclosures Commissioner in the Office of the Ombudsman. The Commissioner will have two important roles. They will assist reporting persons in ensuring that external reports get to the right prescribed person, and where there is no prescribed person, they will take on responsibility for following up on the report directly. This means there will always be a person to receive and follow up on all external reports of wrongdoing. The Commissioner will also take on responsibility for ensuring an independent and thorough follow-up of all protected disclosures sent to ministers of the government. The bill is at an advanced stage of drafting. A number of pre-legislative scrutiny hearings have been held by the Oireachtas Joint Committee on Finance, Public Expenditure Reform at the Taoiseach, and a report of the committee is awaited, so its recommendations can be considered before I bring the bill to government for approval to publish and to commence the passage in the houses of the Oireachtas. Unfortunately, it won't be possible to enact the new legislation before the transposition deadline of the 17th of December, but I do think it's important that the extensive scrutiny work carried out by the Parliament is given an opportunity to report so that Parliament can have a meaningful input at pre-legislative stage in relation to the legislation. And while Ireland is far from the only member state to find itself in this position, I do regret the fact we won't have the legislation enacted by mid-December, but it is essential that Parliament has its say and that they conclude fully the pre-legislative work which has been underway now for some time. And in addition, it is so important that the legislation, which is of such importance, is done correctly because of the consequences for whistleblowers when this legislation, which is intended to protect them, fails to work as expected. We know that that can have devastating consequences. But I do expect to receive the report from the Parliamentary Committee shortly, and I will without delay then publish the full bill. I expect that to be done before the end of the year and for it to be enacted in the first quarter of next year. So there won't be any significant delay. The effectiveness of any piece of legislation can only be measured through how well it is actually implemented in practice. And my department will be stepping up its efforts in this regard to guide and support employers in preparing for the new regime. In particular, the statutory guidance for public bodies on implementing the Act will be comprehensively overhauled. An interim set of guidance will be issued as soon as possible after the bill is published, and will among other things provide clarity for the period between the 17th of December, when the directive comes into force, and the date in which the legislation is enacted shortly afterwards. The full final guidance document will be published when the legislation is actually enacted. A new training framework is in the process of being put in place by the Office of Public Procurement for staff and public bodies, responsible for managing the reporting channels that must be put in place under the legislation. This will meet the requirement under the directive that such staff be professionally trained. The evaluation process concluded recently, and the contract with the successful provider will be signed very shortly. Guidance will also be provided for private sector employers to enable them understand the requirements as regards establishing internal reporting channels and procedures when the bill is published. In addition, in order to support reporting persons and meet our commitments under the directive in relation to the provision of advice to reporting persons, I've provided for an increase of 30% in the budget for next year in respect of the grant funding my department gives to Transparency International Ireland for the operation of its Speak Up Helpline and Transparency Legal Advice Centre. I understand that this year marks the 10th anniversary of the establishment of the Speak Up Helpline, which was one of the very first Transparency International advocacy and advice centres to be established in Western Europe. I think it has provided advice and support for hundreds of workers since then, and I would like to acknowledge and commend the work of Transparency International Ireland in this area over the past decade. We continue success into government's full support in all of the work that you're doing in this important area. To conclude, a strong legislation is an important component in any ecosystem designed to support and protect whistleblowers, but it's also crucial to have the right organizational culture that will encourage workers to speak up without fear of any reprisal. This will do more than any legislation or policies or procedures to support and protect whistleblowers. Driving cultural change in organizations is difficult, and in this regard I want to acknowledge the valuable contribution the Integrity at Work initiative does in bringing about this cultural change, because without that change, changes in legislation will not in themselves bring about the overall change and the improvement to the system that we need. We do need cultural change. And finally, I want to thank you, John, and the team in Transparency International Ireland again for inviting me to say these opening few words for the commencement of your conference, and to wish you all the very best between now and Thursday of next week as you fulfill what is a really exciting and comprehensive program of events. And I've no doubt that everyone will find it most enjoyable, educational, and indeed productive. So thank you again for the opportunity, and best wishes for the remainder of your conference. Thank you, John.
Thank you, Minister, and thanks to the Department for the support over the last few years in providing assistance to whistleblowers through the Helpline and Law Centre. Look forward to seeing the bill when it's published. No doubt you'll hear from us again on this, and we would encourage everyone else as well to input into the draft, or to have their say on the draft when it comes before the Dáil again. Minister, I won't keep you any longer. I know you have a busy schedule, but thanks again for taking the time, and we'll talk again anon. So we'll move on to our first panel discussion, and we will, bear with me a moment, we're joined by our guests from the US, Netherlands, and the UK. And good afternoon to everyone who's just joining us for this session. And we'll spend the next hour and a quarter or so discussing developments in international whistleblower protections, with a particular emphasis on the EU directive. And I'm delighted to be joined by three international advocates and practitioners who will discuss the directive and how whistleblower protections are evolving in the European Union and elsewhere. We're joined, I'm delighted to be joined by three colleagues and people with extensive experience in providing support to whistleblowers. And the first, who should need no introduction, is Tom Devine. Tom is legal director of the Government Accountability Project in Washington, D.C. He's been representing whistleblowers since 1979 and helped over 7,000 whistleblowers since then. He hasn't lost a case since 2006, according to his bio. I don't think that's changed any, Tom. And has successfully litigated at state and federal level, all the way to the US Supreme Court. He's also an international advisor and advised on 34 pieces of legislation. I'm proud to call him a colleague, a fellow trustee of the Whistleblowing International Network. And we work together in lobbying for the European Union Whistleblower or Whistleblowing Directive. I'm also proud to work alongside Ida Nowers, who is a law and policy coordinator at the Whistleblowing International Network, where she is responsible for monitoring the implementation of the directive. Ida was previously senior advisor at the UK Whistleblowing Charity Protect, providing legal advice and practical support to hundreds of whistleblowers and consultancy and training to public and private organizations on implementing effective institutional whistleblowing arrangements. And last but not least, we're joined by Wilbert Thomason, who is the chairman of the Dutch Whistleblowing Authority, in Dutch, the House for Klokkenluiders, or bell ringers, I think it's the direct translation. And he's been chairman of the Whistleblowing Authority since July 2018. Between 2011 and 2018, he was a member and then vice chairman of the Dutch Data Protection Authority. And prior to 2011, he was a leading public prosecutor in different regions in the Netherlands. Sorry, I just skipped ahead there, and in Aruba. So I'm going to turn firstly to Ida. And Ida, the directive promises to strengthen and harmonize protections for whistleblowers across the European Union. However, as we heard from the minister there, that the transposition is likely to be delayed. Can you update us on where things stand now across the bloc?
Yes, thank you very much, John. So we are now just 3 weeks away from the deadline of the 17th of December. As of today, according to the monitor, and I'm actually going to post a link to the monitor into the chat for the participants to have a look what we have online. There are just 2 countries which have adopted legislation due to come into force on the deadline of the 17th of December. That's Sweden and Denmark. 3 countries have yet not started, and not to name names, but those are Cyprus, Hungary, and Malta. We have heard that there is work going on behind the scenes, but for the monitor, because this is a citizen engagement tool, we wanted to promote or encourage governments to be transparent about the work that they were doing. And so unless there's a public announcement about a development that's taken place, it doesn't appear on the monitor. And around 1/3 of member states, 27 member states, have a draft bill or a draft proposal. And there has been, as you said, a lot of delay in that process, and some concerns around lacking transparency, inclusiveness around consulting with stakeholders or conducting a public consultation on the draft proposals, but also some elements of really good practice, and in that all of the responses received, whether that's from unions or NGOs, any stakeholder or interested party, has been published online, for example, in the Netherlands and in Sweden. I would say that there are just a handful of countries other than Sweden and Denmark which will be passing laws either on or very shortly after the deadline. And it's going to be a very interesting time because the directive has what's called direct vertical effect, which means that a citizen of a European member state cannot be treated detrimentally if their government has failed to transpose the directive. So we're going to have a situation where citizens may have rights under the directive, but in a country which hasn't yet got a transposition law passed. So that's a very quick update of where we are, a snapshot of where we are.
And what do you think are the main reasons why member states are so slow in transposing the directive?
I think the elephant in the room in that sense is probably the pandemic. Obviously resources and government time has been taken up with pandemic response. But I think having looked at the transposition process of other directives, delay is not actually that unusual. And I heard that Spain had only quite recently passed the GDPR provisions. And I think that this is quite a difficult law to pass. There are legal barriers, but also we're talking about 27 very culturally different and diverse legal systems. And trying to implement the minimum standards of the directive across those varying landscapes is a real challenge for policymakers, and also for institutions, employer associations pushing back sometimes during consultation on what the scope of the new law should look like.
So, I mean, you're talking about some pushback from different groups here. What are the key issues here? What are the stumbling blocks or points of resistance or discussion across the European Union? Many main themes coming out of this?
Yeah, so I mean, there's many issues, a shopping list of issues when it comes to implementation and different opinions about what the law should look like. But if I take three, I think the first would be the material scope. So what are the types of concerns that a whistleblower can report and receive protection under the law? So because of the nature of the legal remit of the European Union, the directive could only require member states to protect breaches of union law. Now, the Commission has later recommended or strongly encouraged governments to go beyond and expand the protections so that a whistleblower can report breaches of national law, for example, to create that horizontal framework, a cohesive and coherent framework. That was the raison d'etre of the directive. Now, some voices across Europe are strongly in favour for what we've been calling a verbatim transposition or a minimal transposition, which would mean that only breaches of European law or union law are protected, and there would either be a separate system of protection that may already exist or may not for other breaches, or simply none. And this is going to create what we've called a hybrid system. Now, that some of those voices may think that a minimal implementation may be less onerous financially or from a practical point of view, but actually, more recently there has been, in the debates I'm hearing, a tidal change to see that actually having this two-tier system will be very difficult to implement within institutions and within the legal framework as well. Secondly to that, I think the issue of reporting channels, both internally, that's the requirements on business to have whistleblowing reporting channels, and externally within competent authorities. There seems to be an ongoing debate or confusion around what the directive says. So the directive establishes an obligation on certain sized business to establish reporting channels. Some business sector voices have been very keen that is really minimally transposed. So, for example, the directive talks about employers with 50 or more staff. A minimal implementation would mean that in organisations with less than 50, there may not be the requirement to have reporting channels. But that has been interpreted differently in different member states. So again, if you are a business operating across different jurisdictions, in some regions, you will have requirements which you don't have in another country. So that may undermine, again, that cohesive pan-European framework.
I mean, there are two. I mean, we can come back to this again. And there are two points there which are worth expanding on. I mean, the horizontal application of the directive. Thankfully, it looks like the directive will be transposed in Ireland in a way it was meant to be, which is to protect workers or whistleblowers irrespective of whether they're reporting a breach of national or EU law. we wait to see the bill, its final iteration. But that's something we can come back to, along with the controversy around reporting channels. But before we do, I'll turn to you, Tom. You've advised countless whistleblowers, is it around 7,000? Say it's more by now, and been advising governments around the world since whenever it was you began this work. What advice would you give to member states transposing this directive? Is there any one particular piece of advice you would share?
Well, I think this is a critical crossroads for our movement. And if the EU properly implements the directive as intended, it's going to be a landmark paradigm shift globally for the quality of whistleblower laws. Now, at Government Accountability Project, we say whistleblower laws are like free speech shields. And you go into battle with a metal shield, it's dangerous, but you have a fighting chance to survive. You go in with a cardboard shield, no matter how beautifully it's decorated, you're going to die. And we're in the midst of a global legal revolution. When I first came to GAP, there was one country with a national whistleblower law, the US. 1978, they passed it. The second one was in Great Britain in 1998. Now we have 47 nations with national laws, 48 with Iceland. With the EU directive's implementation, there'll be 62 countries. But far too many of these laws are cardboard shields, false advertising. And in effect, they're very counterproductive because people invest a lot of time and money and spend years struggling to get an official rubber stamp of whatever was done to them. And oftentimes have to end up paying the legal fees of the people who retaliated against them. So it's essential that the EU get this right. And to me, there's probably about a half a dozen key priorities for nations to be sensitive to. And the first is, I'll put an exclamation point on IDA's top priority, harmonizing the national whistleblower rights and the EU whistleblower rights. Otherwise, there'll be widespread confusion, inconsistencies in the boundaries for freedom of speech, and that'll have a chilling effect and it'll be chaotic for the nations implementing the laws. The second thing that I think is very significant is not just the scope of topics that are covered, but the scope of communications that are covered. It's essential that the national laws with respect to internal reporting in particular, which is where over 90% of whistleblowing occurs, is internally, that protect all communications of information protected by the directive, not just allegations to whistleblower offices. If that's the case, we'll end up stifling the flow of communications that's necessary for institutional checks and balances, because people will proceed at their own risk. And anytime there's a problem, they'll have to run to the whistleblower office, which isn't structured for that, doesn't have the resources, doesn't have the capacity, will be creating a real mess. And while the directive emphasizes the structure of these new channels, the definition of internal reporting is clear. It's any communication of information protected by the directive, not just those allegations to a particular office. And we at GAP, we kind of nickname that duty speech. People whose job is to blow the whistle, the auditors, the compliance officers, the investigators of an organization. And in particular, every employee has the duty to tell the truth and raise problems within the chain of command for his or her professional responsibilities. That's going to determine whether the directive protects the tip of necessary information or the whole iceberg. The third thing that I think is very significant is the boundaries for these legal rights. And in particular, the key magic word is reasonable belief. Reasonable belief will control whether you have free speech rights, whether you're a valid whistleblower or somebody who's open season. Reasonable belief will determine whether or not you can go public before you make internal disclosures because it's an emergency situation where there's conflict of interest. Reasonable belief determines whether or not you have a whistleblower defense against civil or criminal liability because you need it to make your disclosure. This word has to be defined properly in a way that's objective, that doesn't depend on the whistleblower's motives or their popularity or whether we like them or dislike them, but based on whether or not they have information that their peers, those with similar knowledge, experience, and training could agree with. If that's the case, then it should be on the table. The fourth is the burdens of proof for winning or losing your case. That's how much evidence it takes. If the bar is too high, it's impossible. If it's a reasonable bar of evidence, you have a chance to defend your rights. The directive needs clarification in the national laws. The text of it says that the employer's burden of proof is that the final decision wasn't based on whistleblowing. Well, that could mean like it's 49% illegal, 49% retaliatory, but 51% innocent. The recital explains, no, that's not what was meant. It's not okay to be partially illegal, partially retaliatory. The recital points out that the whistleblowing cannot be linked in any way to the action which is being challenged. And it's essential that that specific boundary be incorporated into national laws, or we could be legalizing 40% reprisals. The fifth suggestion is fully developing the infrastructure for these internal challenges. This is a whole new institution that the EU is setting the pace for. And in my experience, if they're not properly structured with independence and expertise and resources, those channels can be a trap. And in fact, it can be one of the most dangerous jobs in an organization to staff those channels because they get the whistleblower treatment. If they're properly constructed, it's taking the principles of the directive and building them into the structure of every organization. It's a critical challenge. The sixth one is to put meat on the bones for the anti-retaliation protections of the directive. It's very clear about how to blow the whistle. It just speaks in generalities about things like your remedies, temporary relief, disciplinary actions to prevent retaliation. Those need to be fleshed out. And finally, transparency. Transparency, the directive is excellent on for how much money is being saved thanks to whistleblowers, how they're making a difference. But there's nothing in it about whether or not it's effectively protecting people. Whether it's, what's the record in terms of how many retaliation complaints, are people winning them? How long does it take? That's going to be up to each country. I think those are the primary challenges, John.
Yeah, thanks, Tom. I did ask you for one piece of advice. I got 6. So that's I would expect no less, Tom, than for you to share all your thoughts on this. And there's plenty in there for us to come back to. I've spoken before. I remember when spoken before about the need to be cognizant or aware of the risk of creating false expectations or hopes with whistleblower legislation. And when the Protected Disclosures Act was enacted back in 2014, the minister at the time, Brendan Helen, wasn't happy with me because on radio I described it as a stab proof as opposed to a bulletproof vest. It'll provide some assurance to whistleblowers that they are afforded some protection, but it won't, in spite of the safeguards in place and the relative strength of the legislation here, protect everyone in every situation. And we need to be aware also of the limitations of legislation, whistleblowing legislation, which is why I'll come back to you after we've heard from Wilbert about potential structural and institutional reforms that might be needed to protect whistleblowers as well. So Wilbert, thanks for joining us again, and just wanted to hear from you about your experience with the House for Clock and Loiters, and what you've learned from your experience, and how you think concerns raised by whistleblowers will be treated any differently, or whether they will be treated any differently once legislation is transposed in the Netherlands and elsewhere.
Thank you, John, for inviting me. I've been, first of all, I've been thinking about what IAW was saying about the delay, and the delay not being very unusual. So not most of the EU member states not making it before the midst of December. And I think she's right. It's about the pandemic. It's about different cultures, political systems, and being in NEIWA, the Network of European Integrity and Whistleblowing Authorities, founded, by the way, in The Hague, and you're connected to The Hague because I live in The Hague. We see all those different aspects and problems that colleagues of mine all over Europe are struggling with. But there's another thought I have, and that is that delay isn't that bad. What is bad is a proper transposition of the directive, and that's maybe where the problem is. Allow me, John, just a few remarks. Now, it's a sort of run-up to the Netherlands and my experiences in the Netherlands. The directive, what it does, it sets a minimum level of protection for whistleblowers, and then I underline what is important for me, and I think for everybody. It's a prohibition in any form of retaliation against a person who reports a breach, a wrongdoing, or whatever. It's ensuring adequate sanctions to be imposed in case of a person is retaliated against, and provide for sufficient support for reporting persons. That's essential, amongst other things. But that's for me. Right for now, it's essential. It's still a run up to the situation in the Netherlands. I specified 2 points. The first is the idea that filing a report on a wrongdoing is a societal matter. I feel, therefore, we in the Netherlands feel, I think that my colleagues feel, that the reporting person shouldn't carry the burden itself, the burden of reporting a breach. So adequate support for a whistleblower, for example, by establishing a fund that helps them in judicial procedures or whatever, is essential. That's the first remark. And secondly, what I think is very important, and I get back to that in just a moment, I think, and I'm convinced that each member state should have a central authority, an authority which continuously raises awareness, John, and keeps tracks of the national implementation and functioning, sort of primus inter pares between other competent authorities in the member state. Whatever functions this authority has, what we need is a recognizable authority with a name, a face, a phone number, and I think that will have great added value to the whole system of whistleblowers. Now, to the Netherlands, what I don't think, John, is that the direction will change that much in the way we investigate in my organization, investigate and advise whistleblowers. What it does in the Netherlands, the most important consequence is that the reversal of the burden of proof, but by then you're in court, and my organization is far much earlier in the process. Most of the time, so that's quite important. It doesn't change that much the actual way of the work and the doings of my organization. What I do hope, I'm afraid I have to say a little bit, John. What I did hope is that the directive and the transposition of it would change the position, the power, the authority, but then not a capital A authority of my organization. It more or less, it strengthens the way that we are regarded in the Netherlands. You know, what we have learned, my organization, Huis voor Klokkenluiders, indeed, House for Whistleblowers, bell blowers, or whatever you call it. We started in 2016. I joined in 2018, and we had quite an eventful history, I can tell you. We were understaffed. We started ill prepared, I can say now, although I wasn't there. And we were confronted with quite a lot of people who had been waiting, literally waiting for the organization to start, and had high expectations. And given the understaffed and given the ill preparedness, not everyone, and that's an understatement, could be helped adequately. And that led to negative reactions in the press, in parliament, NGOs, wherever. And I think in the last years, I'm quite proud to say so, a lot of things have changed in a positive way. And still, I can tell you, we are struggling not only for sufficient resources, but also with a sometimes negative public image we have coming from the past. So that's one thing it's essential for me, whatever you do, as in Ireland, when you institute this commissioner for the protected disclosures, means staff and give this organization authority it needs. It's an uphill battle. It turned out to be an uphill battle for me and my hardworking colleagues in my organization. That's the first observation. Secondly, what we missed and what the directive asks for, and I'm still advocating, I have to be honest with you, in the Netherlands, are administrative sanctions. I'm a little bit jealous of hearing your minister refer to the sanctions that he foresees under the amended law in Ireland. I have not been successful on that point. And I think that the possibility to impose sanctions as an ultimate remedium, John, at the end of the day is crucial, as it gives us in the Netherlands and everywhere in the EU the power to push through when necessary. Authorities like ours, government authorities, we are basically not NGOs, and it defines us a little bit. We not only need to speak and to convince and whatever, but now and then we have to be able to carry a strong stick. That's secondly, and then I go back to the character of my organization. We have a combination of tasks in the Netherlands. It's advising, we investigate, and we share knowledge. It's prevention, and that all under one roof, I think, makes us a central hub for everything that concerns whistleblowing and integrity. And I have to say that on that point, I'm convinced that this combination of tasks in the Netherlands creates valuable synergy, and I cherish them. And what I at least see is that these three tasks are also codified in the directive on whistleblowing. I mentioned, only to finish my first introductory remarks, John, I mentioned the need to be very independent. We are independent. That is, I'm fully satisfied about that point. And finally, let me point out, and we are working on that in NEIWA, it's the importance of international cooperation. We in NEIWA, and by the way, Mary Ellen Ring and Rodi Butler from Ireland are deeply involved in NEIWA, very good colleagues, working hard. We have our next conference even, is a Dublin conference. To my regrets, it has to be digital, of course. International cooperation, learning from each other, stimulating each other, looking after each other even is crucial. For now, John, please.
Yeah, thanks, Wilbert. You touch on a point I've already broached with Tom, and that's the importance of having strong institutions. We don't have a tradition of administrative sanctions in Ireland. So senior public servants or civil servants would rarely be sanctioned other than under disciplinary procedures for failure to meet their legal obligations under any statute. And Tom, if I come back to you and Ida as well, I mean, how is there anything we can learn from the US and UK experience in sanctioning civil servants or public servants who fail to meet their legal obligations in respect of whistleblowers, who penalise whistleblowers? Is there any institution or any learning from institutions in the US and UK or good practice that we might learn from here? And before I come to you, by the way, feel free to post questions and comments in the chat or the Q&A. Bear in mind too that we are recording this session, and it will be made available on our YouTube channel from tomorrow afternoon. But Tom, if we come back to you or Ida on that question.
Ida, would you like to go first?
Sure. I mean, in terms of public servants, I'm not hugely up to date with the situation in the UK at the moment. I think there is focus on the Civil Service Code. There has been a number of cases involving a whistleblower retaliation in the civil service that have been quite high profile. But I know that in the finance sector, after the global financial crash, there was the banking standards, a sort of look at what had gone wrong, which had led to the meltdown. And the lack of whistleblower protection was picked up as a key cause. Now that has resulted in regulation from the Financial Conduct Authority and the Prudential Regulation Authority, which I think is very good in that it links these new whistleblowing rules to have certain institutional channels, to prevent gagging orders, to allow disclosure to the regulators, and to appoint whistleblowing champions with the senior managers regime. So if you are an accredited person within the City of London, because of you are a senior leader, for example, to meet the standard, if you were to breach those rules, if you were to retaliate against a whistleblower, then your professional standing would be called into question. There are a couple of other instances I'm aware of where there is this linking. Most professional standards do have a clause where if you were to bring the industry into disrepute, you could have your professional standing assessed. And I think it's arguable that if you're retaliating against public interest whistleblowers or not handling, you're ignoring public interest concerns in your sector, you are bringing the industry into disrepute. But I think that that's an interesting way of having personal responsibility for whistleblowing retaliation. I'm not aware of many other across Europe that I can give you as an example today, but of course in France, under the current law, pre-transposition, there are criminal sanctions for breaches of confidentiality of serious wrongdoing in certain organisations. And we've seen a similar clause coming up now in Poland and some other member states. Yeah,
we have criminal sanctions under the 2011 Criminal Justice Act here for penalisation or retaliatory action against whistleblowers reporting serious economic crime offences, but I'm not aware of any cases arising from these. And I think it's a similar. I think that there's similar sanctions available in Australia, which have yet to be imposed. We'll come back to you on that again, Ida. But Tom, did you have any thoughts on this? I mean, how's for example, the Office of Special Counsel working, the Inspector General system working there? Are there any other examples that we can learn from?
Well, they're certainly active. Whether or not they're working effectively is another conclusion. And you know, as one of the pioneer whistleblower laws, we've had the longest opportunity to learn from our mistakes, and we've made plenty of them. I think the most fundamental lesson learned is reinforcing this, how essential it is to harmonize the rights. In the United States, we have one whistleblower law for the government employees, another whistleblower law for the government contractors, a series of them for the private sector, depending on which industry, separate system of laws for state and local workers. Nobody knows what the boundaries are, for sure, of when they have free speech rights and when they're proceeding at their own risk. This creates a lot of unnecessary retaliation, just because people who fly blind run into mountains. And it also has a chilling effect. But that's hardly the only lessons learned from our country. To me, equally significant is that due process that's independent of the executive branch is essential. Relying on a remedial agency is just inherently going to be frustrating. It's fine to have a remedial agency for people who can't afford to go to court and they want to defend themselves. But the chances of success are very, very token. Those agencies don't have the resources to help all the people who deserve it. And further, they're very vulnerable to political pressure. They get the whistleblower treatment if they're too aggressive protecting whistleblowers. It's not a reliable structure. It's good as a safety valve, but you need due process. The third thing is that the laws have to cover the full scope of harassment, not just of retaliation, not just workplace harassment. And that's where the United States has really fallen behind the pace of Europe. People are literally hit with multi-million-dollar slap suits that will destroy them forever financially or prosecuted. And those are both a lot scarier than getting fired. The US needs to learn the lesson from Europe on that. The fourth is that the burdens of proof are essential. If the rules of the game are rigged so that you don't have a realistic chance to prevail, the law is a trap. And we went through a deep evolution in our burdens of proof. And before we modernized them, whistleblowers would win about 10% of their cases. After we modernized them, for those statutes, they would win 25 to 33% of their cases. It makes a difference. The fifth thing is that settlement is so much more beneficial than conflict. In the United States, about 20 to 30% of the people who file cases settle them and are able to get on with their lives. About 10% net win their cases. Your chances of success without years of ugly conflict are much, much higher. And it's very difficult to go back to work for a boss you've just defeated in a lawsuit. So with a settlement that's a win-win, both sides can learn how to live with each other. And very, very closely connected with that is the key for the laws making a difference and for settlements facilitating them is the availability of temporary relief, of interim relief. These cases drag out 5 years or longer routinely. And by that point, it doesn't really make much difference if the whistleblower wins. Their life's already destroyed. They've gone bankrupt, their family's fallen apart, they're totally ruined in their profession. They can't restore their credibility. It's like, you have a great heart surgeon come in to do a heart transplant, but the patient's already dead. It doesn't matter anymore. And further, if there's not effective interim relief, the employer has every incentive to sustain unnecessary conflict, because until there's a final ruling in the distant future, they're winning. Whistleblowers on the street, they've purged that person. There's a chilling effect. But if there's temporary relief, the employer is losing, and they have every incentive to stop the bleeding. I think that's the most significant thing for laws making a difference. And finally, I'll say a lesson learned from something that's in the US laws is beware of bounty statutes, of paying whistleblowers rewards to blow the whistle just for whispering in the government's ear. This has made it very difficult for us to develop the cultural solidarity that's necessary for these laws, because instead of being people who are risking everything to defend the public, their employers identify them or as Judases who are being paid off to betray their colleagues. And the chances of getting a boundary are token, while the paranoia that those statutes have created has significantly increased the rates of retaliation. In our movement, our first duty is do no harm. And this is a dimension which is helping lawyers, but harming whistleblowers.
Yeah. I mean, just sometimes call it the whistleblowing lottery. I mean, your chances of getting a big payoff are relatively remote.
It's like winning the lottery.
Yeah, exactly. Wilbert, I mean, you raised the issue of institutional support and touched on the need for adequate resources, as well as administrative sanctions. Is there a tradition in the Netherlands of imposing any sanctions on public servants, civil servants who fail to meet a legal obligation? Do you think this is something that would make a difference there?
No, at least you're not in this field, and I've been missing it dearly. I could tell you. Basically, it's about working in an organization that has, at the end of the day, what I would like to call teeth or not, and that's what we're missing. And if you don't have teeth, you need sometimes these strong stickers. I've called it before to gain authority. Authority, but not the capital E, but to be seen and to be heard, and that's what is important. Let me elaborate a little bit more on sanctions, because no misunderstanding what I'm talking about. The sanctions for organizations, being public or private organizations. I've been a public prosecutor for 25 years, and I sometimes say that I've penalized enough for the rest of my life. So it's not something that I'm after, but you need it. So criminal sanctions. For criminal sanctions, you need a prosecutor who has time and has an organization who is fit to investigate, for instance, retaliations. And I can tell you, my former colleagues in the Netherlands are capable of doing almost everything and working hard, but I don't see them investigating retaliations. Then what Tom underlined, and I fully agree with him, is the limited possibilities of civil procedures, the high burden, the costs, the long time. It's at the end of the day, then it's an individual against the organization, and it's not a realistic alternative for having an administrative body like mine imposing sanctions in cases people who reported wrongdoing or whatever are really retaliated against. And that's why I'm pleading for sanctions. It's the only realistic alternative if you want to, if you come to the core of this directive and our own legislation. So that's why I made that point, and I find it quite essential. I'm advocating for it in the Netherlands, and I have to say, much to my regret, that I'm not very successful in this up until now.
Yeah, I don't foresee any provisions in the bill allowing for our Protected Disclosures Office to investigate penalisation of workers. I may be wrong. I'm open to correction there. I think the emphasis will be on assessment and investigation of disclosures rather than on the penalisation of people making them. And the tradition here has been to allow the courts or labour court system, the Workplace Relations Commission, and I'm sure you have an equivalent body in the Netherlands too, to adjudicate on cases of allegations of penalisation or dismissal of workers, rather than to create a separate entity for investigating those concerns. I'm aware of a number of investigations into allegations of penalisation, nonetheless, overseen by government departments. But I think I'd agree with you, Wilbert, and Tom too, that we need a coherent and very visible system that avoids confusion, that encourages people to bring their concerns forward at as early a stage as possible and seek redress through a system that they can have confidence in without setting unrealistic expectations at the same time. and there'd be a great deal of work to be done to inform the public about the respective roles of these agencies and their limitations as well. Because we find ourselves, we run a helpline, we provide advice, we triage cases, we can send people, or we can refer people to secure or seek legal advice, but we can't investigate. And very often the expectation is there that we'll name and shame public servants or government officials and politicians when we have a very specific role, and it's limited by both our legal powers, which we don't have any formal legal powers, and also by resources too. I think I have some sympathy with you there, Wilbert, at the House for Clough-and-Loiters. I think the expectations were sky high of the agency, and I think you've seen this as well, Tom, in the US, where inspector generals are sometimes used to distract attention away from a lack of political action. We saw the Trump administration use inspector generals, and it's not the only administration either to single out inspector generals for special treatment. But we often see these agencies thrown under the bus, so to speak, when failure is somewhere else down the line. I'll come back to this point again if we have time. And there was a question here from Anne asking us what our thoughts were in relation to conflict checks in a reporting authority upon receipt of disclosure. And Tom, you've already kindly added shared your thoughts on this, saying that conflict checks are essential. I just wondered if we touch on the point about anonymous reporting too. I mean, how do you Wilbert as well, how do we make sure that these type of concerns around conflicts of interest are addressed in most cases? And Ida as well, are you familiar with that much debate going on at EU level around how anonymous reporting will be dealt with, what kind of institutional safeguards will be in place to protect the confidentiality of whistleblowers too? So Ida, if we come back to you on that point, do you have any thoughts on this?
So I think anonymous reporting is one of the issues within the directive that's really been affected by the different cultural attitudes towards whistleblowing. And the appetite to allow anonymous reports varies wildly across the different member states, and understandably so, because in regimes which have are post-authoritarian, the idea of passing anonymous information to the state, to government or regulators, has a negative connotation around denouncing or snitching, that sort of thing. So it was left open in the directive. The directive is clear that if anonymous whistleblower is later identified, they should receive the same protection, but it allowed member states to choose whether or not to facilitate or mandate the acceptance of anonymous reporting. There's a difference in approach in the draft bills that we can see, but there's a strong argument to allow organisation, competent authorities or business to facilitate anonymous reporting, especially because some of the technological advancements around reporting platforms and two-way anonymous secure communication do overcome some of the challenges that there are to investigating and protecting anonymous disclosures. So I think it's yet to be seen what exactly that will look like. But it's one of it's one of the provisions which there'll be a lot of variance, I think.
Yeah. Tom, did you have any
Yes, in addition to anonymity, confidentiality for confidential whistleblowers is essential for that whole goal of protecting identities. And I think this is something that's quite impressive in the directive. It's really reflects the best of global best practices. The national laws have to protect not only the identity, but identifying information, facts that could be traced back to them. Before disclosing any identifiable information, there needs to be advanced permission from the whistleblower so they don't get blindsided. If it's non-discretionary, such as a court order to expose the identity of the witness, the whistleblower is entitled to advance notice. And so they're not taken by surprise that they've been outed. And finally, when the information is transferred from whistleblower office to another institution to investigate, the confidentiality pledge has to travel with it. It doesn't end with the original audience. And it's just a matter of really respecting and making sure that those details are in the national laws. So the other dimension that's essential is security. Security for the transmissions that are made anonymously, using the highest quality technology that's available, and security for protecting the documents within the whistleblower offices. So it's a very, very high stakes objective because it's the only one that's foolproof to prevent retaliation.
Wilbert, I'm sure you've received, or the House for Clock and Lawyers has received its fair share of anonymous reports. How have you dealt with them, or have you seen the authority change or adapt its approach to these concerns or handling these concerns over time?
I have quite a practical approach to that, John. Look, what we are doing basically is spending public money. So I have to ask myself every time, again and again, am I competent here? And so that doesn't influence the question whether or not someone wants to say anonymous. But what has to be clear that the question or whatever they want from us, it has to be work related. So that's something that I always want to know. Is it work related? Am I basically just competent according to our own law in the Netherlands? So if it comes, and that's very practical, to wrongdoing, breaking the law or whatever, it's and we are convinced that it's work related, I see no problem, no burden to investigate, or better, most of the times, to refer a matter to a more suitable authority. When it comes to investigating retaliation, though, and that's quite obvious, it's almost impossible already for practical reasons to investigate a case in which someone wants to stay unknown. So that's my practical approach. If it comes to wrongdoing and it is work related, we as an external channel, what we basically are, we will work upon it. When it comes to retaliation, I can't see ourselves for practical reasons to try and investigate or whatever.
Yeah, I think it would be, I mean, we advocate that concerns raised, irrespective of whether the discloser's identity is revealed or not, that point to wrongdoing and contain enough information for the recipient to take action should be dealt with irrespective of whether they're anonymous or not. But clearly there's going to be always a problem in protecting someone who remains anonymous, because they can't, it's very difficult for them to assert that they have made the disclosure in the first place unless there's a paper trail. And we suggest that making an anonymous report uses a traceable system like a secure email, or has some record, or keeps some record of their interaction with the recipient. I just wanted to move on briefly, if we can, and just ask you all, and we haven't got any more questions so far, but please, we still have another 15 minutes or so. To ask you all if what measures you think contained in the Irish legislation could be replicated elsewhere, and where you see room for improvement in the Irish legislation, if you feel comfortable in commenting. I'll come back to you, Ida, to put you on the spot, sorry.
I think in terms of where other member states might want to look at the Irish framework, would be around not defining what a whistleblower is too strictly and how a disclosure can be made. So as long as it's a disclosure of information within those categories of wrongdoing made to one of the person's sort of internal, external, or even publicly. We haven't spoken much about public disclosure today. Then it would be protected. But we can see already the discussions in other countries being around, as we mentioned very early on in this session, it only being protected if it goes through their internal whistleblowing channel or to one single competent authority, and some of which there are questions around how independent they would be from government. So I think that in terms of what Ireland can teach, if you like, the rest of Europe, that would be the main area. In terms of where Ireland's new proposal, I was looking at it just before we came on, I think there's this interesting point around interpersonal grievances not being protected. The directive is clear that good faith shouldn't be a reason to remove protection, if the whistleblower is not acting in good faith. And I think if we start talking about interpersonal grievances as a way of removing protection, it's sort of good faith through the back door. I know as a whistleblowing advisor that there are grievances and disciplinary action flying all over the place within an organisation. And actually, whistleblowers may be raising their whistleblowing concern within a grievance. It may even be combined with other interpersonal issues, but making sure that we detach those two things is going to be really important, because otherwise public interest issues will be missed and we're not protecting staff or whistleblowers, and that will have a chilling effect on other staff to speak up later on.
Yeah, thanks, Ida. Yeah, I mean, this is something we've encountered quite a bit on the helpline too. Sometimes protected disclosures are indistinguishable from grievances because the two overlap so much, or protected disclosure might be made in the course of sharing a grievance. And so it's something we've highlighted and brought the government's attention to already. Tom, did you have any thoughts on this, or any were there any good and not so good features to the Irish legislation that you think we can learn from?
Well, I would just share that we had the same problem with grievances in the United States. It was kind of a loophole, an exception, and we modified the law so that it's a grievance connected with whistleblower retaliation. The rights are the same. There's no difference. To me, John, the biggest challenge for Ireland is, all laws can be perfected, but it's getting folks to take advantage of your law. Australia and Ireland are two of the top 3 nations in the world for the quality of the rights on paper, but both have had only token number of reported cases. And see, for people to be taking advantage of these. So much more ambitious agenda for training, so that people are aware of their rights and their responsibilities as managers, so that they know that they're actually crossing the line and breaking the law. And public education of the benefits and the potential, how this can make a difference for people. really reflects a problem globally of underutilization. In our GAP did a study with the International Bar Association evaluating these laws, not just on paper, but in terms of their usage and their won-loss records. And 59% of countries had no reported decisions under their whistleblower law. And it was 89% had less than 5 reported decisions for their whistleblower law. These are dormant rights right now, and it's a real challenge to have people start taking advantage. And a question came up in the chat about Article 10. Might as well share one of our lessons learned in the United States. We have the First Amendment. I'm sorry.
Article 10 of the directive, just for
Article 10 for the European Court of Human Rights, I believe. And it's kind of equivalent to the experience we had with the First Amendment in the United States. It's, freedom of speech. It's the cornerstone of our country. But it was, when it was expanded for government employees, it set up a balancing test. And that's been the case with free speech rights under Article 10 as well. And when you have a balancing test, the whistleblower doesn't know whether or not he or she has rights at all when they open their mouths. They won't know until the end of the court case to say, well, was this really something where it was justified for you? It creates a real severe chilling effect if you have to guess whether or not you can defend yourself or not, or entitled to. And in the recent Hallett decision at the European Court of Human Rights, contrary to the directive's standards, they found that, well, if we don't put somebody in jail and we just fine them a modest amount of money, it's not so bad. That's okay. Well, it's established criminal liability for blowing the whistle under Article 10, whereas the European directive gives you an affirmative defense against that, which didn't exist in the other context. The value of the directive versus Article 10 is it gives clear boundaries of absolute rights rather than having to guess at whether you win a balancing test. But that's why it's so important that the national law is transposed with clarity and specificity, so people don't have to guess.
Yeah. Thanks, Tom. We've had a couple of additional questions in the Q&A, and one from Kate Kenny asked, "Can settlements be designed so the wrongdoing is addressed, or is it typical to see NDAs, non-disclosure agreements, that prevent this?" Wilbert, can I ask you, what your experience is in dealing with NDAs and settlements, or has this issue come up at the authority?
We're in the midst of a discussion in the Netherlands concerning NDAs, because NDAs stand in the way of proper reporting wrongdoings, basically. So we are strongly against NDAs. If people turn to us for advice and ask about NDAs or whatever settlement shall I go into with my employer, we always warn them about the consequences of entering into an NDA. So that's basically my point. I have to admit that we are talking about the NDAs with the legislator. NDAs are prohibited in the environment of hospitals, doctors, and whatever, because it's essentially about life and death there. For the rest of society, we're still working on the question whether or not NDAs should be in a law, should be prohibited by law. But we obviously are strongly, most of the time, strongly against entering into an NDA.
Yeah. I mean, just for clarify, an employer cannot contract out, is the term used in Ireland, of their legal obligations under the Protected Disclosures Act. We don't foresee any change to that situation or scenario here. There was a stumbling, one amendment made in, I think, 2018 to our Act, imposed additional burdens on the whistleblower where they were accessing, sharing, or using information that might be considered a trade secret under the Trade Secrets Directive. Hopefully that anomaly will be addressed in the amendment bill, and that the EU Directive on Whistleblowing will supersede any requirements under the Trade Secrets Directive. There have been a couple of comments coming in as well here, but we're about just under 10 minutes left. I'll start with the last one because it's shorter. How do the panel feel about companies investigating protected disclosures internally or using an external independent investigator, given the changes coming under the directive? I'll put that out there, whoever wants to take that question.
In the Netherlands, John, up until now, so current law, the idea is that a report is investigated first internally. And if it's not being done properly internally, then they can turn, the reporter or the whistleblower, whatever, can turn to the external channel, which basically up until now is only my organization. And this will obviously change after the transposition of the directive. I guess it's typically Dutch, and I say it without any qualification in mind, but it's typically Dutch to prefer parties, employers, employees to settle things amongst themselves. And you could argue very well that this is better for organizations to learn from a report, and that it's better to find a settlement amongst themselves than with our help, and it's always better than an organization being sanctioned. That's obvious. But it's clear that according to the directive, it's possible to go externally immediately. But I do think, and I do expect my colleagues always to ask, why didn't you report it internally before you came to us, or whatever other external channel? Excuse me.
Yeah, Ida, did you have any thoughts on this?
There's three considerations which come to mind. Firstly, in very small organizations, it's going to be hard to find someone impartial or independent enough to investigate the concern. So I can see a place there for business having some. So I know that some large organizations and small have, a list of persons on file. But it's about building trust and confidence with staff that you're going to handle this in the most prudent way. The second thing I would say is, having worked with some of the health trusts in different countries and finance, that encouraging employers to be quite open at an early stage with the regulator, that we have these concerns, and then seeking guidance on whether an independent investigation is appropriate or not, in the spirit of transparency. But one of the risks that I can see that we should be cognizant to is where an organization is conducting an internal investigation with lawyers and then cloaking all of the investigation findings within legal privilege. And then when an independent or regulatory investigation happens later on, they're saying that the findings of that investigation are legally privileged and cannot be touched. They're sealed, if you like. There's been arguments of that we've seen shut down, keeping things secret unnecessarily.
Yeah, Tom, thanks, Ida. I think we often see cases that are subjected to investigation by external investigators are sometimes, for the same reasons you spell out there, Ida, not put it into the public domain, or the response isn't seen as is not made visible because sensitivities surrounding the case, and I think this is going to be an issue arising across the EU as the directive is transposed. Tom, did you have any thoughts on this point?
Well, yes, there's competing interests. The point of the directive is to get information into the right hands for responsible exercises of authority for the people who need to know and properly follow through on this. And when you have when you're contracting out that function, you're creating a middleman, and that's inherently going to be less effective communications and knowledge, rather than the people who need to use that information if they're acting responsibly. But if there's a conflict of interest, having an internal investigation is almost like obstruction of justice. It can be that you're providing all the evidence of misconduct to the wrongdoers so that they can have an advance opportunity to cover it up and destroy documents and intimidate witnesses. And so in that context, I think you need to have an external investigation that's available. But really the boundary for when it's better to be totally internal or delegated internal through a contracting out would be based on conflict of interest for the subject matter. Are there independent experts to follow through on the whistleblower's concerns who aren't targets of the allegations?
No. Thanks, Tom. We're coming to a close here. I'm not sure if we've missed any questions, but we did get a comment from our colleague Lorraine Heffernan, who's acting managing solicitor at the Law Centre, Transparency Legal Advice Centre, saying that a recent Scottish Internal Tribunal decision held that both the CEO and the company jointly and severally liable for an award compensating for detrimental treatment against a worker for having made a protected disclosure. What role does the panel think personal liability could have to play in this arena? I'll give you 1 minute each if you have an observation on that point about personal liability.
Well, I'll offer an opinion. Personal liability is essential. Otherwise, the bullies have nothing to lose. The worst that'll happen is they won't get away with it, and the person who's willing to do the dirty work will almost certainly be promoted or get some sort of positive reinforcement for willing to do it. If it's institutional liability, just gets passed off as a relatively modest externality, a cost of doing business. There has to be personal consequences and accountability to have a deterrent impact.
Wilbert? Or sorry.
Yeah, I do understand. I do understand what Tom is saying, and of course I agree. Although on the other hand, and let me stress out that from my position, as it comes to the protection of reporting persons, as well as creating a safe working environment, enabling a speak-up culture, it's extreme. It's essential that also the organization functions as well as a safe haven for reporting, for investigating, for whatever you want, and that's why I stressed an hour ago the need of having sanctioning power. When I say sanctioning power, my first thoughts are about the organization retaliating against persons, but also what we didn't mention, maybe my last contribution, this requirement of building reporting channels where you have more than 50 employees is also something that up until now, at least in the Netherlands, isn't underlined, so to say, by any sanctioning. So if you do not do that, then it's not an individual, then it's the organization who has to be, in my view, at the end of the day, punished for not having the essential requirements in place. So I agree with Tom. It can be about individuals, but it's, for me, it's very important that we speak to the organization, being it government or private organizations.
Thanks, Wilbert. I'd I'll leave the last word to you on this.
Well, I agree with both Tom and Wilbert in their comments. I think personal liability in that sense, and they're talking about the UK here, for detriments tend to be less financially risky from a litigation risk point of view, but you can have dismissal as a detriment now as well. It's been found in the employment tribunal, which could be devastating financially to somebody found guilty of being retaliatory. But as Wilbert says, it comes down to having good internal practices for managing risk assessing retaliation within an organization. And that's where I think the ISO 37002 is helpful, and really identifying and managing retaliation at an early stage. And possibly just finally the role of mediation to prevent these very scary cases that we see coming through to the courts.
Yeah, I take your point as well. You made a moment ago too about some of these cases being shrouded in secrecy once they're subjected to legal privilege, and making the difficulty that can be faced by external agencies in reviewing a case where, when the lawyer's being called in, it's important in many instances to address those concerns sometimes in a less formal and legalistic way, so as to see the wrongdoing addressed rather than the focus being placed unnecessarily on whether the disclosure is being made as set out in legislation. I think there's a risk across the European Union on overly formalizing protected disclosures, when what people making protected disclosures are only seeking to do is to raise concerns in most instances of wrongdoing. They don't necessarily have to seek protections under the Act. They want to use those legal frameworks to get the message out and see that action is taken in response to them. I wouldn't do justice by trying to summarize this conversation, but I will thank you. I should use this opportunity to thank you, Wilbert, Tom, and Ida, for joining us. Let's say thank you for all our participants for taking part and joining us today. Like I said, this conversation will be posted online on our YouTube channel tomorrow afternoon at some stage. We'll let you know when it goes live, and please feel free to share any questions or ask for any information or guidance you think would be helpful in adopting measures that you'll have to, as employers, adopt as the directive is transposed into law here. I will hand you over to Stephanie, who will tell you a little bit about tomorrow's session, I think.